speaker is Avvocato Gian Luca Zampa, who is a partner with the Freshfields, Bruckhaus and Deringer law firm and specialized in antitrust. Thank you.
Thank you. Thank you, Margarita. Thank you, Paolo, for inviting me, and congratulations for this very interesting and, as always, very spot-on conference. When I was invited to speak on this panel, I think I was intrigued by this topic, then just to be disappointed immediately afterwards because there was nothing really on which I could draw my thinking in terms of literature, both in economic terms and legal terms. So that was even further a challenge, but even more intriguing for us. And before, sort of, when you think about the topic of my presentation and of this panel in general, you immediately have one question and one observation. The question is this really any different from the normal private enforcement of antitrust law by private companies? Is there any reasons why things should be treated in a separate way? And the observation is that, as a matter of fact, we don't see enforcement actions brought by public bodies to the extent that we see them now, these days, initiated by private companies. So with that in mind, I started thinking about the topic, and I will try to illustrate my thinking today. So I will essentially touch this point today. I will try to be as quick as possible given the time constraints that we have. So I think that the first point, the first point is very easy to take home because this is exactly the reason why Paolo organized this conference, which is, public procurement is very, very important. It represents a large chunk of the economy. It represents a large part of the public expenditures, and even more so in a moment where we're trying to cut budgets and public expenditures. So you have the first precondition. So a large number of transactions occur through public procurement, and that should attract also collusive behavior. When we talk about public procurement, I think we are not just talking about strictly sensu public procurement, so they procure the tenders, public tenders for the purchasing of goods and services. When we talk about public procurement and competition issues, we also talk about public contracts, and we are talking any public tenders for the selection of an assignee of a public contract and public concessions in particular. Public concessions, for example, for carrying out economic activities which are reserved to the state or have special features in terms of access to it. So transportation, services, gas distribution, etc. And that tells you that the story, it's even wider, is much broader than the numbers that I've showed to you in the previous slide represents. It is really a big part of what of the economic activity of a country. And moving to the Italian experience, I think my esteemed colleagues before in the panel before us already expressed this point. The activity of the Italian antitrust authority on public procurement in this broader sense has been very, very impressive, and you have, I think I counted more than 15 cases opened at least in the last 3 years, which fall under this category. And it has already been mentioned before that public tenders alteration is in itself already a criminal offense. So bid rigging is the only competition infringement which has also this feature, which is not a coincidence, but it's because it's very important. And clearly, alteration of public tenders may occur also through corruption, and the interlinks between corruption and collusion, I think, was explored yesterday to a certain extent, and it's probably one of the most important issues that public procurement agencies have to deal with anyway. The authorities also showed its interest in public procurement by publishing guidelines that also have been mentioned earlier on today, which have gone to procurement agencies, small and large procurement agencies, in order to sort of solicit draw their attention to the fact that it's not only corruption but also collusion that could have an impact on their outcome of the bids and on the institutional missions that they are pursuing. The Italian Trust Authority also has entered into a protocol agreement with a very important authority these days in Italy, which is the Public Contracts Authority, which essentially has been considered to be when you have a problem in Italy, you go to the Public Contracts Authority for whatever reasons, and in particular for public procurement. So we have also the OECD principles that clearly represent a very good, important, and very important framework of analysis for detecting public procurement infringements through collusions. So we have the two elements here. We have the importance of public procurement, the vast part of economy represented by transactions occurring through public procurement, and then we have the interest of authorities because there is an history of alteration of public procurement. So with these two elements, one would expect to see a lot of actions in court, because every time you have a damage created by a competition infringement, you are entitled to recover your damages in court. And so before entering into the details of that, I think it's important to try to detect what are, if any, the differences between public-private enforcement, so the enforcement of antitrust law by public bodies in court, and private enforcement antitrust law, which is the much more common, although still in its infancy in Europe and in Italy in particular. But you see, it is visible. It is something that you can really see. It is mounting. So there are a number of technical differences. Some we will see are more important than others. But we are trying to isolate the differences in order to try to see whether any of these explains the difference in terms of what we can see on the market. So in terms of standing, so who can bring these legal actions? And with public procurement, you have a very wide, different type of situations that may come into play. You may have the small public local entity that procures certain goods or services, or you have the centralized procurement agencies like Consip in Italy, which is very sophisticated, and highly performing. And however, when you have these centralized systems, or you have consortium or third parties, companies dedicated, or public companies dedicated to this task, well, you may have problems about standing because, for example, Consip typically they enter into framework agreement with the suppliers, but they don't buy actually the products. The products or the services are acquired by the ultimate public entity, which is availing itself of the framework agreement. In that case, for example, it is not the procurement agencies that would have standing to bring the damage action. And so you would have to try to find ways in order to either stimulate the smaller local entities to bring the action, or to delegate the right, or assign the right to bring to assign the claim and bring the legal action to the procurement agencies. Then standing in case of collusions before procurement agencies could also come from the excluded competitors, although boycotts is not really a common feature of public procurement competition infringements, but it may happen depending on the design of the auction, and so you cannot rule that out. And thirdly, typically this is not an area where you have consumer associations or consumers that could step in and take the lead in bringing the actions, save for certain parts of the certain public contracts. Let's imagine a public concession, the concession for transportation services, where part of the bid relates to the tariffs that will be applied downstream to the customers, and therefore if there is collusion between the participant in that bid, the effect of which is to raise the tariff that the winner will be entitled to apply to the services downstream, then clearly there is a direct effect for these consumers, but it's very, very minor. It's not the core aspect. So normally you don't have indirect purchasers situations in relation to public procurement. Other technical differences are, for example, on quantifying damages. When you are on the side of the spectrum of sophisticated procurement agencies, clearly they know their job, and they know, in principle, what the costs for producing certain goods or providing certain services are, much more than sort of occasional buyers on the market. Another difference could be the counterfactual when you carry out the economic analysis and trying to determine what is the competitive, what would have been the competitive price absent the collusion. It's difficult to have a clear-cut counterfactual, because each tender could have a different design, could have a different scope, a different size, etc. So it's not impossible, clearly. I'm just saying that it's different from the typical private enforcement scenario. And probably the most, to me, striking difference that you can see as a matter of fact in public procurement is that whoever is on the other side of the potential litigation, that is the defendant, the suppliers that have colluded rigging a bid, they don't normally have the possibility to use what is the most important defense that you have in these cases, which is the passing on defense, because the state is normally the ultimate buyer, and therefore there is no question that whatever is the overcharge, if any, has created a damage to the state that they are entitled to recover. So that is another difference which in principle make you think about what implication you could draw from this situation, and see what is the reasons why we see less actions. The point, however, and I will try to make this appear as we'll try to see how this plays out together in a moment, is that these technical differences in themselves only tell me that there are differences, not that there are a situation where you have more difficulties in bringing actions because you're a public body as opposed to a private entity. I think the more correct way of looking at the problem is to try to see what are the incentives and the constraints that a public body may have when thinking about bringing a legal action for damages against suppliers because they've rigged a bid. And if we go on the left-hand side of the slide, and we see the incentives, and you can see that clearly the public, it's another side of the story we told before, which is the public procurement agency has a lot of information about the potential damages that it may have inferred. Assume that we are clearly in a context where, and we will see that in a second, you have in a situation where an authority have concluded that there has been an infringement of competition law, so you know that there has been an infringement, you know how this has played out, and you have the decision. You have just to quantify damages, which is something that economists these days are doing very frequently. Paolo is one of them, but in this particular case, he would have much more information and more precise information from a public body if it is a professional procurement agency than in normal cases where you struggle to try to get the information from the other parties. Then another incentive is what we just mentioned. There is a very limited or absence or very limited scope for a passing on defense, which means it's, you are more likely to succeed if you're a public body as opposed to a private party. You don't have that uncertainty. What Giancarlo mentioned before, the danno erariale, which is a law which is very stringent in Italy, which is binding on public officials and civil servants at large, which essentially tell you that if you create a damage to the state, then you are individually accountable for that. And this is not something that just if you break the desk where you're working, at which you're working, but also if you omit to carry out actions with gross negligence. And clearly the more legal action is likely to be successful, the more negligent you are if you don't bring that, and you can be directly accountable for that. So there should be there is an incentive for public bodies to think about bringing a legal action as such against its suppliers. And then legal costs play both ways, because legal costs and expenses, clearly if you're on the winning side, as under the Italian procedural system, there is that the winner, the loser pays the legal costs of the other parties, although it doesn't really work in full and cover all costs. But it's a principle that if you have a strong case, well, you should bring also you have that additional element that could justify requesting a budget for it internally. On the constraint side, however, you have a number of other elements which probably can explain why we don't see many of these actions this day. And the first one is what I mentioned before about who is the victim of the overcharge. Let's imagine that you are CONSIP, a procurement agency. Let's assume that they are buying, or large procurement agencies, they are buying themselves, and they are sophisticated, they have all tools, and it's easy for an authority or for the general culture to reach these procurement agencies because they are professional. Then you have smaller, instead, victims. Imagine in a situation which is currently the current situation, where the procurement agency only provides the contractual framework and the prices at which things are purchased, but the actual purchasing orders are issued by local entities. In those cases, you have the subject and holding the claim right, the right to bring the legal action is not CONSIP, is the individual, and then you have to convince a number of. It's like you have more or less the same issue that you have in class actions type of situation with small claims. And a fragmented demand, which renders unlikely bringing very, very costly and complex legal actions before against the large suppliers. Then what I think Giancarlo core message in its paper was, you have to partner with your suppliers. You have an incentive to extract as much quality as possible, and you have to take that into account when deciding what to do. And that is, again, a constraint, and that could really explain the situation. And then you have the others situation like standing, and it's just a procedural matter, but may create problems absent a specific rule dealing with these matters. And then again, the same danno erariale, the same accountability that we mentioned before, which is an incentive to bring the legal action in the first place, could also play negatively on how these actions are eventually terminated, or whether they are successful or not, because as we all know, these actions typically are settled out of court. You reach a certain point where both parties find convenient to reach a settlement. And at the same, at that point, however, if you're a public official, then you feel a little bit constrained in accepting, let's say, 10% of the original damage claim, because at that point you may be accused of not having dealt diligently with your role. And because it's an individual liability, then you may feel constrained to do so. So that is, I think, a very important element to consider. Very quickly, so what may be changing these days? I think Margherita mentioned the big change in Europe is the implementation of the damage directive, which this year, at the end of last year and beginning of this year, essentially is being implemented across Europe, and in Italy was implemented in February. And this is clearly, and this the reasons being, the hopes that Giancarlo mentioned before of the Commission was that this would promote private enforcement of antitrust law, irrespective, however, whether the actual plaintiff is a public or a private company. And what are the main changes that I think are important? The first one is decision of a national competition authority. We have seen that there are 15 cases very recently decided, represents a binding decision for the judge. So the judge has to apply the decision. So there is no need for plaintiffs to prove that there has been infringement of competition law. I think this is the most important point probably for what is relevant here. There is a presumption of the existence of damages, which means that once an infringement of competition has been established, there is a presumption that there is a causal nexus between the infringement and a damage. Clearly the quantification of damage needs to be proved. The presumption could be rebutted, but still it's a facilitation tool for plaintiffs. You can ask as a court to have the Italian Trust Authority intervene. The chief economist could be asked to come and make a deposition in court and support a conclusion one way or the other. And another important procedural point is, without reaching the level of Anglo-Saxon discovery rules, there are procedural orders that could be asked to the judge, essentially, which imposing to the plaintiff, to the defendant, to release a number of confidential documents that could help plaintiffs to bring its case. And so these elements are elements that in principle would tell you, well, then because of this shift, this increased facility, we should see not only private enforcement actions increasing, but also public enforcement actions, particularly given that if you're a public official and the action is becoming more and more easy to deal with, well, your personal accountability increases in parallel. Again, without going into the details, because I'm probably using too much of my time, actually these are important shifts, important changes, but these are not dramatic changes as far as the Italian system is concerned. You had a number of points, on the points that I raised before. For example, it's true that the decision of the competition authorities were not binding until the recent implementation of the damage directive, but they were, however, deemed to be privileged evidence of the infringement, which at the end of the day is not so different, could be different, but not so different from a plaintiff perspective. And there is also already a mechanism in place whereby economic experts are going to assist judges in determining damages, and therefore this is already there, and probably this will remain as the main source of economic evidence as opposed to the intervention of antitrust authorities. We all know that the European Commission decisions were already binding on courts, so that is not a big difference as well. And so on and so forth. So the essential point is it's very difficult to see a dramatic change with damage directive. There is a change. There is private actions will be more facilitated, but not to the extent that we can see a complete change as the Commission probably hoped at the beginning. At this point, I was trying to see, well, given the incentive and constraints that we've seen before, and how can we deal with those, given that the damage directive's implementation is not really changing any of them. And so before entering into what with Giancarlo we discussed in a call, and with Anna and Margherita as policy considerations and food for thoughts for everyone, I think it was interesting to see what you know, to make one you know, general comment is that you know, antitrust is not unique. It's not the only sort of law pursuing a public interest that could be applied in civil courts as the legal basis for obtaining damages by a public body. And so a very sort of high-level comparison could be made, for example, with environmental law, where you have a number of similarities with antitrust laws in terms of legal structure, not only, of course, in terms of content, which is, well, both laws essentially are trying to address, you know, they're trying to specifically protect public interest. They are all the legal basis for tort actions, where you have to prove, you know, prove the infringement, the loss, and the causality nexus. Where you have an issue of standing, particularly when there is, imagine, a big pollution by a large industry affecting both the air that we all breathe, the ground, the private ground of you know, neighbors, public grounds for parks. And so you have a number of potential stakeholders that need to have standing, and the state could represent most of them because of its role and its sophistication and its ability to do something that the individual citizen may not be capable or willing or knowledgeable enough to carry on. In both cases, you have very complex damage quantification criteria, so you need expertise, you need, you know, cases are complex. And again, the states, the officials may have an accountability issue if they don't bring these actions. So you have similarities there. At the same time, you have differences again, and this is sort of the common theme of my presentation. It's antitrust at this point in time, despite having been there for, you know, from the inception of the EU treaty, and in Italy from the 1990, has clearly a different perception, I think, with respect to environmental law. Environmental law is known by everyone. It's very easy to understand when you have a problem, what can create for your own personal situation, while you know, economic damages are less close to the citizens or to the people and to the politics, essentially. So this, you know, that translates into cultural differences clearly, and it's more obvious when you talk about even before a judge. Well, judges are much more reluctant to grant damages for a possible overcharge than for having destroyed, you know, the purity of water in a lake in the mountains. Another difference is, again, to speaking to Giancarlo's point, is, well, in environmental law, you don't have suppliers as partners. So, you know, when the entities bringing these actions for damages against a polluter, don't really have anything to say to the polluter as such for future supplies. So there is no connection there which could prevent you from being more active on that front. In antitrust law, you have a more facilitating point, I have to say, on the other end, which is, you know, you have an authority that is prosecuting, or two authorities that are prosecuting in Italy competition infringements, and therefore, with that decision in your hands, you are able to sort of go in without the need to prove the infringement itself. And again, the possible difficulties in settlement is more complex on the antitrust front. So, trying to wrap this up with some policy considerations, I think the core of my presentation essentially tells me that the differences existing between private antitrust enforcement and public-private antitrust enforcement are not that many, but are at least some that would need to be addressed one way or the other if we want to see more public-private enforcement in action. And this is the concluding slide. I think there is some food for thoughts for the legislators in relation to try to address the standing point and the conflict point in terms of the relationship with suppliers from a legislative angle. On the one hand, trying to establish who has standing, which in itself would also resolve the issue of the conflict of interest if and to the extent standing is granted to public bodies which have not as primary responsibility the procurement of goods and services. So by making this uncoupling work, you could create a better alignment of interests and with private and public companies on this front. Again, also the accountability of the officials, I think, would need to be addressed, not only because, as we have seen, it is conflicting in itself, because on the one hand, it provides an incentive to bring the legal actions, and at the same time, it also prevents reasonable settlement from occurring, which essentially kills the likelihood of success of these actions in most cases. And more general, I think this is something I think we have to recognize to the Italian Trust Authority, the need to spread the culture of competition law, and also in terms of private antitrust actions is really important, particularly given the heterogeneity of structures that you could have from the public procurement sides in terms of structure, from concept to the small hospital up in the hills. And with that, I concluded my presentation. Thank you very much.